hi all, welcome you again. So let's begin our first keynote session. And now I'm here with Mr. Leopoldo, who is gonna have a keynote session first, where he will talk about challenges to patentability posed by AI. So let's have a very warm welcome our first keynote speaker, Mr. Leopoldo Belda Soriano, Head of Patent Examination at the Spanish Patent and Trademark Office. A very warm welcome, Mr. Leopoldo. Now it's over to you. So let's begin our first keynote session. Thank you.
Thank you very much indeed for your warm presentation. As you said, I'm going to talk about challenges which this new technology that is everywhere nowadays is posing to patentability. I have a background as a patent examiner. I was a patent examiner for more than 10 years, and now I am in charge of around 25 patent examiners. Even though I didn't start as a patent examiner in artificial intelligence, I grew interested in these subjects. I have attended lots of conferences, and I'm going to try to share my knowledge about this issue with you. When we talk about artificial intelligence and patents, we can distinguish two main issues: patentability, that's what I'm going to talk about, and also the use of artificial intelligence for patents examination in searches, in management of administrative procedures, lots of things, but we don't have time for that. Maybe that can be left for the future, for new conferences in the future. And when talking about patentability, we can also distinguish several issues. Patentable subjects matter. That's what I'm going to focus mainly. Also, who has the rights to the patents in artificial intelligence generated inventions, about prior art generated by artificial intelligence as well, assessments of inventive step, where the main issue is the definition of the person's skills in the arts, sufficiency of disclosure, which is a really controversial issue when talking about artificial intelligence and patents, and also liability in patents infringements by artificial intelligence, which I won't have time to talk about that, but it's interesting to know what happens if a patent was infringed by artificial intelligence, something similar to what happens with autonomous vehicles in case of accidents. But I'm going to focus on patentable subject matter. Maybe you are wondering whether artificial intelligence can be patented or not. The answer is, well, it depends, because we can distinguish several types of inventions when talking about artificial intelligence. The first one would be artificial intelligence as software or computer implemented inventions. The artificial intelligence used as a tool that makes it possible to obtain inventions. And finally, something that we are some decades from nowadays, which are inventions generated autonomously by artificial intelligence. In my opinion, that's something from science fiction for the time being, but maybe we have to start studying it. Of course, I'm going to talk about what's practiced in Europe, in Spain, Europe in general. When we talk about artificial intelligence as software or computer implemented inventions, they are patentable. They can be patented as long as they have technical features, and inventiveness, non-obviousness, inventive step can be attributed to those technical features. You might wonder, yes, but what is technical? Yes, that's a good question. And technical, usually in Europe, we consider that something is technical when there is a controlled use of forces of nature in order to obtain a result. However, as you know, artificial intelligence and machine learning are usually computational models, algorithms. Usually they are of an abstract nature. So in general, they per se cannot be patented. And the European Patent Office has published a guidelines, a new edition of its guidelines for examination, and there it warns you about something you have to be cautious about. because you know that in artificial intelligence we have terms, expressions such as supports vector machine, reasoning engine, neural network, etc. They might sound technical, very technical, but in fact they are of abstract nature and they couldn't be patented. But yes, there are some AI-related inventions that do have a technical character and can be patented. This is an example that has been put forward by the European Patents Office of an invention where artificial intelligence plays a very important role and can be patented, which is the use of neural network in heart monitoring apparatus for the purpose of identifying irregular heartbeats. That's the case where it can be said there is a technical contribution and it can be patented. There you have the first page of the patent application. You can of the patents granted, already granted, you can see that the code B2, which means it was granted. And here you have the claim, the independence claim that says heart monitoring apparatus comprising inputs means, preprocessing means, and neural networks means. And here it explains how the neural network works. Also, according to Practice Europe, all inventions that have to do with classification of the digital images, videos, speech signals, they are considered to have a technical character and they can be patented as well. Here you have an example. For a computer implemented methods for training a deep convolutional neural network. It's the way the neural network is trained in order to be able to classify images of skin lesions and to say whether they are cancer-like lesions or not. That's another example of inventions where artificial intelligence is involved and can be patented because there is a technical contribution. And now we can talk about the use of artificial intelligence as a tool to obtain inventions. There are numerous companies nowadays that are doing that. That's very common in the fields of pharmaceutical industry, where artificial intelligence is being used, for example, with the following goals: identify new compounds, foresee how those potential compounds will behave in trials, analyze possible combinations of existing drugs, find new uses of existing drugs, personalized medicine. Here you have an example. This is a PCT application, use of tryptophan derivatives for protein formulations, and there you have how computer learning algorithms are used to predict susceptibility to oxidation. Here, this is a piece of news that appeared some months ago, where you see that for the first time an AI-designed drug entered human clinical trial. The article says that especially that's the main advantage of artificial intelligence in these fields of new drugs, that artificial intelligence can learn faster than conventional approaches. So we had to make and test only 350 compounds, a fifth of the normal number of compounds. So that's the main advantage. It speeds up the whole process. Also, given the present situation we are worldwide with the present pandemic, there are also groups of researchers that are using artificial intelligence to try to identify new compounds. There you have also a piece of news about that. And as I said, the main issue is that it makes it possible to speed up the process of designing, testing, and making potential new drugs. This is very common nowadays. There are some companies that are using AI platforms to try to generate inventions. This is a real case in Europe. We have a company which has an invention platform based on artificial intelligence. It uses machine learning, natural language processing, graph theory, etc. You have to feed that platform with data. You have there articles, white papers, blogs, research papers, whatever is available. You also have to feed the platform with a model of how invention works in certain technological fields. With all that information, the platform generates what they call inventive elements. Those inventive elements are provided to humans developers, human developers with a background in the different technologies, and they are able to draft patent applications from those inventive elements. Those patent applications are given to the customers. Usually customers are multinational companies, and then they decide whether they file those patent applications or not. There are some people that say that that maybe behind the huge number of patent applications we are seeing nowadays in China. Last year there were more than 1,500,000 patent applications filed in China. Maybe that has to do with the use of those tools. And that could be worrying for the future, because we might see an avalanche of patent applications if those systems are used. And that could be a problem for patent offices, I mean. And finally, we also have inventions generated autonomously by artificial intelligence. Probably you know this case. It appeared on the news last year. There was a group of patent of professors from England, from the University of Surrey, that decided to file two patent applications in the main patent offices: USPTO, UK Patent Office, EPO, Israel, Taiwan, etc., to see what happens. And they designated as the inventor an artificial intelligence system called Davos. They said it was this Davos that had invented those inventions. This is one of them. This was a fractal profile for containers. And as you can see there in the first page of the European Patent Office patents application, the inventor, it says the designation of the inventor has not yet been filed. In fact, it was filed, but it wasn't human, and because of that, the patent was denied, not only by the European Patent Office, but by the UK office and also the USPTO. This was denied. Here you have some of the arguments by the European Patent Office. All AI systems or machines have at present no rights because they have no legal personality comparable to natural or legal persons. And also AI systems or machines cannot have rights that come from being an inventor. Because of that, the patent was denied. But however, it seems there is a need to solve a problem here. Because last year I attended a conference on the issue in Geneva, organized by WIPO, World Intellectual Property Organization. And there was a person, the person responsible for IP for one of the main German companies, and he showed this example to us. On the right, you have a mechanical piece from a vehicle, and invented by a human. And on the left, you have a similar piece invented according to that person by an algorithm, which according to that person as well complied with patentability requirements, so it could be patented. However, this person said that they couldn't protect this invention with the patents because the inventor wasn't human. So he said there was a need to solve this problem, and he put forward a possible solution that legal persons, companies, could be inventors. Another possible solution would be the creation of electronic personality. Something similar we have in legislation about copyright designs. And also we have this article from UK would be very useful. Here you have, in the case of a literary, dramatic, musical, or artistic work, which is computer generated, the author shall be taken to be the person by whom the arrangements necessary for the creation of the work are undertaken. Maybe something similar could be done in those cases. And let's move on to the next issue when talking about artificial intelligence and patents and patentability, which is inventive step. Here, the main issue would be who is the person skilled in the arts. It depends on the type of inventions we are talking about. If we are talking about inventions generated with artificial intelligence as a tool, probably it would have to be a hypothetical person or a group of people who are equipped with artificial intelligence as well. But if we were talking about inventions generated autonomously by artificial intelligence, which it seems we are some decades off, in that case, probably it would have to be a computer. But that's something from the future. This is a very important issue when talking about artificial intelligence inventions and patents, which is the black box issue and the issue of sufficiency of disclosure or enabling disclosure. And because you know that with artificial intelligence, mainly with neural networks, we have usually a black box. I mean, you have input data, a black box, which is the neural network, and outputs, the results. And sometimes you don't know what's going on in the middle. So in order for a patent to be granted, you have to comply with a sufficiency of disclosure. So patent applicants are advised to provide as much information as possible about that black box. For example, the training process, the way different data are given, the training data sets, the system architecture. It will depend on each invention, but otherwise, if that information is not provided, maybe the patent is denied. Also, there are some experts that call it the black box fallacy. So there is controversy, and a possible solution that has been put forward in some fora is to implement something similar to Budapest Treaty, which is already implemented for microorganisms, but for artificial intelligence. This is a recent case by the European Patent Office where a patent was revoked by the Board of Appeals because of lack of sufficiency of disclosure, because the decision said the description does not disclose which input data sets are suitable for training the artificial neural network. Finally, to finish, because I think I'm running out of time, a wrap up. Some artificial intelligence related inventions can be patented, but there are some caveats. First, there must be technical character. Otherwise, I am talking about Europe, the invention won't be patented. The invention designated must always be human. For the time being, and non-human inventors are not admitted. And finally, there might be problems with the lack of sufficiency of disclosure. So you have to be cautious with that. You have to provide as much information as possible if you want your patents to be granted. So that's all. Thank you very much indeed for your attention. And now if you have some questions or some comments, maybe I will be able to try to answer them.
Thank you so much, Mr. Aldo, for providing a very brief about the patent, and it is very knowledgeable presentation as well. So thank you so much for being our keynote speaker as well. We are open for our Q&A session. So I would like to request our attendees kindly ask their respective question in chat box, and Mr. Leopoldo will gonna answer you, through this video. So can we have the questions, please, in chat? Mr. Leopoldo, you can also check the Q&A in the stage chat.
Okay, I am.
Yeah. And we are also available for online Q&A sessions with Mr. Leopoldo presentation as well. So we can have the questions of our participants on offline, and it will be answerable in the chat box only.
Okay, I don't see any question yet.
Yeah. So meanwhile, we are looking forward to questions. Can we have a big smile from your end so that we can capture this glorious moment? Question from Mr. James Durkin. That is, what is your option on functional claiming? Yeah.
What is your opinion on functional claiming in terms of disclosure requirements? Does it raise unique challenges, means, plus, etc., in the artificial intelligence area? Yes, in this case, in my opinion, in Europe, functional claiming, the situation is similar to what happens with computer implemented inventions. I don't see much difference if we are talking about artificial intelligence or computer implemented inventions. Functional claiming can be admitted sometimes, but you have to take into account what's the common general knowledge of the person skilled in the arts to determine whether there is sufficient disclosure or not. I hope I have answered your question of though it's a general one.
Yeah.
Um,
We have a question
one
from Dipali Pon as well. As well.
Yes, patentability of technical character is generally looked upon similarly to patentability of software inventions. Please confirm. Yes. When talking about technical character in artificial intelligence and related inventions, the way we tackle this in Europe is exactly the same as with computer implemented inventions, software inventions. So yes, I confirm that it is addressed in the same way.
So much, Leopoldo, for answering the question. And we are also available for offline Q&A session, so our participant can ask. Yeah.
One quick question from Dipali. So the Dipali is asking that patentability of technical character is generally looked upon similar to patentability of software inventions. Please
We
confirm.
answered that. Yeah, we
Yeah,
got the
yes,
answer.
I already
Yeah.
answered that question. Yes,
Mhm.
we deal with that issue in the same way
Mhm.
as we do with software inventions.
Yeah. So
But
thank you
this
so
might
much.
change from one country to another. I mean, from one region to another. But in Europe, that's the way we work.
Okay. So thank you so much, Mr. Leopoldo, for joining us today. And it's really nice to having you as a keynote speaker. And we are also looking forward to see you in our future conferences as well.